Hey guys, it's Ryan with Big Dog Investing. Thank you guys for tuning into my channel. If you guys could do a couple of things for me, if you guys go and like, comment, subscribe to my channel if you guys have not done so already. Click the bell notification down below so that YouTube can send you guys notifications whenever I release videos. Watch my videos all the way to the end. And if you guys could share my videos and share my channel with anyone, I'm trying to grow my channel as much as I can, and I definitely need your guys' help in doing so. Getting started, we're going to be talking about the Ripple versus the XRP lawsuit and the orders that the judge handed down in her last brief. This is really interesting. There was a lot of key information, and I will be transparent. Not everyone won 100% of the battles. Now, in my opinion, Ripple won more and a lot more at that. But the SEC did take some wins in this. But, if it was a slam dunk case, if Ripple was going to win this right away, it would have happened. It would not have taken 2.5 years to go over. Now, to get some little bit of a background information about what's been going on this week, I wanted to bring some things up in this video rather than the video that I just released, because I released two videos today. John Deaton says right here that the SEC, etc., is literally losing credibility as each case gets litigated. Whether it's bankruptcy court or enforcement action, judge after judge is affirming that these attorneys lack a faithful allegiance to the law. They're political hacks, full stop. And we talked about this because I just brought up in my last video. If you guys have not watched that, I would recommend watching that one as well. I know it's going to be basically about 45, 50 minutes of your guys' day, but if you guys want to gain valuable knowledge, you guys have to listen to individuals who actually do research. I recommend that you guys do your guys' own independent research. But, I take a lot of time out of my day, and a lot of other people who create videos about what's going on, you know, do this. They do a lot of research. We come up with a lot of information to give to you guys, and then you guys can make your guys' own decisions and what specifically you guys want to do more research in. Now, if you hate my videos, that's awesome. Go find somebody else that you guys like. I'm not here to basically, please everybody. I want you guys to watch my videos. I enjoy doing this. But, if you guys don't like my videos, I'm not your cup of tea person. That's totally fine. But I would recommend going to find somebody that you guys actually enjoy. If you guys do like me, though, again, if you guys can, follow me, like and watch my videos, comment any, thing that you guys want me to talk about, I would appreciate that. But, you're not going to agree with everything that I say, and that's fine. We can always agree to disagree and shake hands, or, maybe I'm able to sway your guys' opinion on certain things, or maybe you guys might be able to change my mind on certain things. Put them in the comments. I'd love to hear from you guys. But getting on with this, the political agendas and stuff that's going on. I talked about in my last video that there was a senator who was receiving a bunch of money and millions of dollars in basically campaign funds. And two of them, out of the top five, two of the five, the first one and the fourth top donors were cryptocurrency related exchanges or hedge funds and stuff like that. And that individual was helping to create a bill based on the cryptocurrency, whether it's for or against. I didn't read specifically everything that's in the bill. These bills are very long. But these individuals have their own self-interest at heart. They get paid a bunch of money in campaign funds with the caveat that they basically follow whatever these companies want, and that's ridiculous. And the judge in this case starts slamming them. So this is for what bankruptcy case. And right here it says the judge is slamming the SEC again. We can start the litigation today so that you have to prove your agency's position. Are you still seriously telling me that you haven't provided any clarity? These are direct quotes. And want me to deny this plan because it might be something you think is something. If the SEC really cared about having some sort of regulatory clarity, they wouldn't have waited 2.5 years for this Ripple case versus the SEC to still play out in courts. If I didn't do my job, and again, I'm a high school teacher, if I didn't do my job for 2.5 years with being court ordered or have the public scrutiny, I'd be fired after like the first 3 days, to be honest with you, if I'm not doing the job the way that I'm supposed to and helping the students out. Because at the end of the day, it's the students' futures that are at heart, and the SEC is supposed to have investors' best interest. And as of right now, they're not even having any best interest because they can't even come up with clear guidelines and regulations. Moving on, though, this is the same thing right here. John Deaton also says the SEC is making shit up as they go regarding anything crypto. In the Ripple versus the XRP case, they argued Hinman's speech was a personal opinion, not guidance. When the judge ordered the emails discoverable, they flipped and argued it was guidance from corporate finance. So this is deflection, deflection, deflection. It's this. Oh, wait, never mind. Sorry, it was this. Oh, wait, never mind. It was this. And in this, in the VGX Heroes Twitter space, they also said the past 15 to 20 minutes have been a lot, has been a flat out dunk fest on the SEC. Wow. The judge says, did you mention any of the publicly before Friday? You yourself just said you don't know. Is the debtor supposed to read the SEC's mind? So, whoever's at fault for the debtor, are they supposed to read what the SEC is supposed to be basically coming up with? Am I supposed to be able to think as a person who is works for the Security Exchange Commissions on how they might argue or think about something? Because obviously they know more about the law than I do. I didn't go to school for this. I didn't go to school for finance. I didn't go to school for law. These individuals did, yet they still can't come up with clear guidelines. Meta Lawman says right here that the SEC is going to be filing a new case. So, shocking new case filed by the SEC. This was in Utah. The SEC has just filed a case alleging that selling crypto mining equipment and offering hosting services for the equipment constitutes as an investment contract under Howey. You read that right. Here's what you guys need to know. If you guys want to read more about this and anything that's in these, I always put in the comments every link and article that I do use. So if you guys want to, I would recommend doing your guys' own in-depth research. Brad Garlinghouse says right here, it's only Tuesday, but shaping up to be a not so great week for the SEC. This ruling for Voyager and Grayscale. And Digital Perspective says, I gotta say, it's nice watching the SEC take a ride on the struggle bus for a change at Brad Garlinghouse. And this is for Stuart Alderadi, because he came out, he's a general counsel for Ripple. Sorry, guys, I'm a little sick. I have been for the past couple of days, and I'm trying to still get over it. That's why my voice is a little bit raspy also. Stuart Alderadi also said, though, that yesterday's opinion from the court on Ripple and the SEC's proposed expert opinions, if you didn't read all 57 pages, here's the TLDR. And this is what I was kind of interested in, because I was like, man, what does TLDR stand for? Obviously, I don't know. So I had to Google it. TLDR says too long, didn't read. That's what it stands for. Now, there's a lot of slang and stuff. Maybe this is common knowledge in law, common knowledge in financial markets because they have long paperworks. I don't know. I'm not a huge reader. So this one was really interesting. But he comes out and says specifically, not only is the XCC's expert on reasonable expectations of an XRP purchaser struck from the record, this is the individual who said that their expert, knew what the average XRP token holder wanted, but so is the expert who tried to say what caused the price of XRP to change. So these two individuals, one said that he knew exactly what the XRP purchaser was wanting and knew what was going to happen. And the second expert knew exactly what caused the price of XRP to change. Well, if you know anything about the XRP token or anything related to cryptocurrency, everything just follows by Bitcoin right now. So if Bitcoin's price goes up, then the rest of crypto goes up. If Bitcoin's price goes down, unfortunately, the rest of crypto goes down. So the XRP and whatever Ripple's been doing has not affected the price of the XRP token. So he also says on the flip side, are experts that explain how Ripple's contracts clearly differ from those in Howey. And that's the test to determine if something is considered a security or not. Tax treatment of XRP, which is not a security, accounting treatment of XRP, which is not a security, and currency experts on XRP are not a security are allowed to stay. And that's important. That's a nice win for Ripple. These both are. Now, again, Ripple did take some L's, and we'll talk about that here in a second. Stuart Alderadi says, as we have said throughout, we have always felt confident of our case, and with each ruling, even more so. So even more so now after the ruling that Torres just handed down. John Deaton comes out, and if you guys want to, you guys can watch this and listen to it. It's a minute and 50 seconds. But basically, he just talks about how the XRP army and what he's been doing for the average XRP token holder, because he actually did come up with a document, has over 75,000 XRP signatures or individuals who are invested in XRP or support Ripple in their fight against the SEC have signed. And He's the one that you would talk about as an expert, and basically you can ask him questions about what the average XRP token or holder would have thought, because he's interviewed token holders and he possibly is one as of right now. Conclusion. So I'm going to read through all of the remarks and we're going to comment on some and some we're going to wait through. So, number one, defendant. If you guys don't know, Ripple's a defendant because they were sued by the SEC. So now they have to defend themselves against the SEC. So, Ripple, which is the defendant's motion to preclude expert one from testifying, is granted as to his first opinion about the perception of reasonable XRP purchaser. So, this is what we were talking about, where they can no longer say that their expert knew exactly what XRP holders wanted or thought was going to happen. And this is because he didn't interview one XRP holder and he is not an XRP holder himself, and denied for the remainder of his testimony. So, once you lose that, you're basically credibility shit. So, that's great news for Ripple. Defendant's motion to preclude expert two from testifying is granted as to the fourth opinion of materiality of Ripple's potential disclosures. And I'm assuming, again, I'm not a lawyer. I read through most of this. It's 57 pages. It's really strongly worded. So I might, miss some things. If I do, put them in the comments. I'd honestly like to get a little more educated on this, especially since it just came out yesterday. But precluding the maturity of potential disclosures, and I assume that this is going to be how many tokens were distributed or sold right in the beginning for their ICO. Or actually, I don't think they had an ICO. If that's the company has an ICO, but it's basically when Ripple gets rid of their XRP tokens and they sell them to investors or individuals who want to buy the XRP token for a currency. And doing that, they're able to use that money to help grow and expand their business, and denied for the remainder. Number three, defendant's motion to preclude expert number three from testifying is denied. So expert number three is allowed to testify. Defendant's motion to preclude expert number four from testifying is granted as to his third opinion about the risks of the XRP ledger might materialize if Ripple walked away or disappeared, and denied for the remainder. This was a really big thing, and this was really important. So number four has a lot of information, and we're going to talk about that. So in a security, so if a business, we'll talk about it from a security aspect because it's easier for people to understand, and then I'll put it into words would be a non-security. But for security, so let's say you guys invested in Apple, right? Once, or we'll take it for example, Blockbuster, right? So you guys invest in Blockbuster, you have a bunch of Blockbuster shares, then Netflix comes rolling around. Netflix starts taking over. Blockbuster starts disappearing, goes away. If you were invested in Blockbuster, obviously your stock price is going to go down. It's the same thing that happens with currencies. If another country that uses a different currency, so let's say the US right here, okay, is this big, big fish. And we'll just say we have the UK over here. They use the euro, we use the US dollar. We decide to take over. So we're going to attack Britain and we're going to basically conquer them, okay? Britain's dollar, okay, is no longer valid, okay? Everything is going to be done in US dollars because we now conquered their company. So the euro is obsolete now that the US took over. And that's the same concept right here with XRP. If Ripple did walk away or left, essentially the XRP token would disappear. Now, the individuals who work for Ripple aren't going to be leaving the company, especially anytime soon. So, this is kind of just a stupid point that they wanted to bring up, and obviously they lost because the judge threw it out. Defendant's motion to preclude expert number five from testifying is granted as to opinions of cautions or causations, what caused the prices of XRP to go up or down. That's important because obviously this person has no clue that everything follows Bitcoin, and denied for the remainder. Now, the SEC's motion to preclude Swoosh from testifying is granted as to his opinion of the Supreme Court's legal reasoning under Howey. This one right here is probably, in my opinion, Ripple's biggest loss. So, their expert Schwartz testified what his opinion on what the SEC's legal reasoning of Howey is. It has a certain number of prongs, and if they meet all the prongs under Howey, they're considered security. It's been proven time and time again by countless lawyers that Ripple's XRP token does not actually meet the Howey requirements. So for this to go down, this, in my opinion, was probably their biggest L that Ripple took, but the SEC took a lot more. The SEC's motion to preclude Um, Adrenas from testifying is granted as to his first and second narrative opinions. Again, those are just narrative opinions, and denied as the remainder of his testimony. The SEC's motion to preclude Borden from testifying is denied. The SEC's motion to preclude Easton from testifying is granted as to his rebuttal report, but his opening report is perfectly fine. The SEC's motion to preclude Dot from testifying is granted as to her third opinion about whether the offer or sale of XRP occurs, and denied for the remainder. That one's kind of important. The SEC's motion to preclude Farrell from testifying is granted as to his illegal opinions regarding the second and fifth opinions and opening reports, and the portions of the rebuttal report are denied to the remainder of the testimony. The SEC's motion to preclude Osler from testifying is denied. The SEC's motion to preclude Fisker from testifying to the first and fourth opinions is granted. The SEC's motion to preclude Marys from testifying is denied. And the SEC's motion to preclude Schaffner from testifying is denied as moot. And that's what I want to point out, the last part, as moot. A lot of lawyers and a lot of judges will put in things whenever they can to kind of throw a little bit of humor, or just point out stupid remarks. And in my opinion, Judge Torres does that right here and says that is denied as moot. So I wanted to make sure that we did a highlight of that. Moving on, though. Bill Morgan. So I was in a Twitter space. I'll show you guys in a second, but he's one person that I started following. He's a lawyer, sports fanatic, digital asset enthusiast. So he comes out and says, I thought when I read that the Daubert motions that I wasn't such a great sign if most of Ripple's expert testimony survived. Most of it did survive. I am glad to see most of Alan Schwartz's report is admissible. It is irrelevant to the blue sky issue, as Judge Torres says. At page 29, how to interpret the Supreme Court's reasoning and Howie is the central question is the issue in the case. Schwartz is permitted to testify about Ripple's contracts and how they differ from Howie's contracts. That is important. So they're allowed to testify how they differ, but not how the Supreme Court would rule under the Howie test. Further, the judge accepted that the contracts and the provisions are relevant to the issue whether an investment contract exists. She found that Schwartz's evidence is relevant to his analysis, and that's why it's allowed. It was also hearted that the judge accepts, page 33, that XRP is having a use is relevant to the inquiry as to the third prong under Howie. So it is useful, okay? It does have utility, and that just takes away from the third prong of Howie, so it should not be considered a security. I thought Adreno's opinion on the issue whether the judge allowed was more important than the two opinions that she did deny. So that I thought that was super important. Wanted to point that out. This guy JV says, so far, expert number 3 getting approved hurts Ripple, the company, the most, in my opinion. See the screenshots. John Deaton comes out. I'm not going to read these because I have a lot that I have to go over. So I would highly recommend that you guys look in the comments for these and read through them. But John Deaton points out and says, but you have to find and cite that the SEC summary judgment motion or rely where the cites this expert. And in my opinion, that they haven't been able to do that. So that the expert can testify at trial if called by the SEC, but the SEC doesn't cite to his testimony or opinions. I don't believe in the motion papers. So in my opinion, this is really interesting. This guy I just noticed says, can Bill Hinman or Jay Clayton be brought and called into trial? This guy says no. Well, anything's possible, but this never happened. It would be revisable error for the court to allow it. It's kind of a stupid question. I just wanted to see what the response was. But they have to look through the records and see if this expert can actually cite where they believe this happens. And in my opinion, that they haven't, and John Deaton points that out. Eleanor Tourette says lawyers in the filing Torres refers to at trial twice. Is there any indication of how she's going to rule on summary judgment? And John Deaton says that he talked about this yesterday. I really want to read through Rule 56, indisputable facts and statements, and contour statements. I agree with the Judge Torres rejects Ripple's blue sky argument that was filed in the second court above. So you believe that a jury trial on the issue or two isn't out of the question. So in this motion and filing, Judge Torres does twice say at trial. So is this the hint that we might be going to trial? I do think so. Now, it's not always the case that they're actually going to realize that the entire case is going to go to trial. There might be certain things that she might need clarity on, and she might want to go to trial for those specific things. But summary judgment, in my opinion, will have some sort of ruling, and then some stuff will go to trial. We don't know exactly what yet. As this case keeps progressing, we'll figure it out. So I joined this Twitter space, and this guy right here says it was a lot of fun. He was the host of it. We had some big hitters: Fred, Jeremy, 24 hours, the guy Bill that I was talking about right here in this. And says, huge shout out to Fred Zeezer for his surprise guest of Jeremy Hogan. Zach Rector was always also in this. I follow him. I think he's one of the great people in the XRP community. But this was going on for a little over an hour and 20 minutes. It was great to hear opinions on things. And right here, they said, well, it was said that the S word was settlement from Jeremy Hogan and Fred Riz. And right here, it says, you got to be happy for Ripple right now, at Jeremy Hogan says, because Jeremy Hogan was quoted saying, if she's going to rule in Ripple's favor, you can see where she's almost setting it up so they don't have evidence or believable expectations of profit, and that they expect that that they do have doesn't bring a lot to the table. If that's the case, you got to be happy for Ripple. And in my opinion, I agree with this. Ripple, in my opinion, is not considered a security. There was no investment in contract, and no reasonable expectations of profits. Because in a sense, I can use the XRP token to buy and sell things right now if I wanted to. If it goes up, it goes up. If it doesn't, it doesn't. Would I like it to? Yeah. But if it doesn't, I knew what I was getting into when I bought into the token. John Deaton also says, it's worth noting, they literally asked judge to revoke my amicus status over the motion asking permission to file amicus brief challenging this so-called XRP holder expert. These Ivy League SEC lawyers aren't the best poker players. And this is what they were pointing out when the SEC got rid, or the Judge Torres denied the SEC's expert in the trial. And Digital Perspective comes out and says, yeah, the 75,000 XRP holders and John Deaton make a difference. Don't believe me. This is the truth. And he comes out and says, XRP holders made a huge difference, as I say in the amicus brief. The SEC's original intent was to rely on the rank speculation of the alleged expert who fails to interview a single XRP holder before forming his opinions. And in my opinion, that's one of the worst things you can do. If you're not knowledgeable on something, just be honest. I'm a high school teacher, like I say. If a student asks me a question, I don't know the answer to it. First thing I'm going to do is say, hey, unfortunately, I don't know the answer, but I'm going to figure it out for you. Because as long as we're honest and upfront, don't lie, don't make up stories. You're going to be more believable. And, no one's a know-it-all. No one knows everything in life. So, this was really interesting because he had every right and every opportunity to talk to any XRP holder and never did. Fred Rispoli also says, love getting through this order. Very well reasoned at page 15, but already the TLDR, too long, didn't read, is that neither the SEC nor Ripple are getting a full summary judgment. And that's what we talked about. And parts of this case are going to trial. At the same time, I think I'll be correct in my predictions on the secondary sales. And this is due to the library token, the judge ruling that secondary sales of library token are no longer considered securities. Digital Assets Daily says, I expect the reason for the case on Ripple to be delayed, and Stewart mentioning that the SC, which is the Supreme Court, is that the judge will rule in favor of the SEC. Then when Ripple wins, as Stewart Algerazi states, in the Supreme Court. At this point, there's no further reason for delay. The new system needs more time. And I want to point that out because Ripple technically can lose against the SEC. It is a possibility. So we have to be wary of that and understand that the things that we do get into, whether it's investments in crypto, whether it's investments in stock or real estate or whatever you want to invest your money into, you can technically lose it if you do not pay attention. Everything has a risk in life. Getting in the car, driving to work, you put your life at risk. You can get a car accident and die going into work. So be grateful for the things that you have and plan accordingly, and also set your guys' self up for financial wealth and freedom, and also have ways that you guys can help your guys' kids or grandkids or whoever's in your guys' family if and when that time does come that, we're no longer here. So getting on with this, though, due to the Supreme Court being mentioned a couple of times, I want to also be transparent and tell you that, again, that they can lose. I don't think that this is going to happen. Again, no financial advice. Jeremy Hogan says this right here. The SEC has to prove that you had a reasonable expectation of profits from Ripple's efforts. And they have to prove that 75,000 individuals had reasonable expectations. And the judge struck down that the SEC's only expert witness on that subject because they didn't interview anybody who's an XRP holder. So now, how the heck does the SEC prove reasonable reliance on who to testify? Just think about that out loud. Well, I hate to answer my own question, but apparently the judge thinks that expert number three opinion as to Ripple's incentives and actions to the influence of XRP price is relevant to the issue of reasonable expectation of profits, but seems fairly weak sauce to me. So this is the one that in part expert three was fully granted. Um, Hogan says that he's an attorney, and he's been following this case for a while, thinks it's weak. And I 100% agree with him. He's more of an expert in this area and seems to be very knowledgeable and hasn't proven anything wrong yet. Fred comes out and says, big takeaways. Number one, think the question, did Ripple sell XRP to become a security, to be like a security, is going to trial, but there is a chance, 10%. It does not. Judge Torres hints at 29 that she strongly considered the blue skies legal argument. Number two, that the SEC took heavy losses, Ripple took minor ones. And that's at 2.8. So there's still more that you guys can read through. I'm not going to go through all of these again. This guy's very knowledgeable, and he also gives what he does think is going to be happening. Bill comes out and says the SEC made allegations to the summary judgment motion and have at least made 6 actions that I can recall in which Ripple took support of increased XRP prices. Those Howey tests are the SEC's case study. Although whether they made much difference or announcements of them made much difference to the XRP price is the issue in despite, and the SEC is weaker on the because the judge didn't allow Dr. Ment's opinion that Ripple's announcements caused XRP price to rise. So they can speculate all they want to, but they don't have an expert to be able to prove this because the expert couldn't come up with an idea or be able to articulate their own point. This one was really interesting right here, and I want to end with these last two things because we've talked about how there needs to be regulatory clarity in the United States. Without regulatory clarity, crypto and other big tech can no longer strive in the United States. So, SEC Schindler rejects crypto's threat to move overseas. So, he's talking about how a bunch of individuals in cryptocurrency space are talking about how they're going to move overseas. He says, I don't really care. I don't think that's going to happen. Jeremy Hogan says it's not a threat because there's no discourse. Businesses are already moving overseas. It is happening as we speak, and I 100% agree. Ripple, the company, is already operating in other countries. Okay, it doesn't need the United States to determine if it's allowed to operate in other countries. Now, Ripple might not be able to operate in the United States or figure out how they can operate as a security if they are deemed, which again, I do not believe that they will be, but they will still be able to work and operate in the United States if they follow guidelines. But even if they don't work in the United States, the XRP token will still be used throughout the world. So other companies are already moving overseas. And the last thing that I wanted to talk on right here is Brad Garlinghouse. So they talked about right here some thoughts from last week's DC visit. I'm stating the obvious, but the crypto industry at large in the United States needs to have a rebuild of trust, both with utility and transparency, due to the FTX, Terra, and more. It's the only way we collectively move forward, and I agree with this. The headwinds keep growing. The SEC declaring war on crypto. Chair Gensler continues to harp the firms simply need to come in and register. But the truth is there is no infrastructure in place for a registered token to trade or nor any clarity as to what these tokens are. If you want to regulate, then regulate. Put the hard work on to build a framework and set guidance, as many other G20 countries are already doing. The 27 EU member countries can agree on a set of rules with MiCA, what's stopping the United States. And I 100% agree with this, and I want to leave that there. Again, this is just an update from what happened with the Ripple versus the SEC case because Judge Torres did make a bunch of rulings, I believe 15 of them in total. I would 100% recommend reading the 57 pages. I'm going to be finishing that. I'll talk more about it if I find anything else. I did want to mention one thing though in this Twitter space that I was a part of. One guy did bring up an interesting fact. I don't remember exactly who it was. I think it was Fred, but they talked about how if Ripple does win, the XRP price could go up drastically over 2 weeks. And in that 2-week time period, if I'll talk about it in the comments